From the heart of our nation's capital, here's Family Research Council President Tony Perkins.
The Supreme Court yesterday, some significant cases on religious freedom, on churches. One out of Colorado. We've had positive decisions in the Ninth Circuit where churches that have been fighting for some time now are getting relief. The U.S. Supreme Court telling governors, hey, back off, you're employing a double standard. And it all kind of goes back to a really important decision just a couple of weeks ago out of New York when the slapdown of Governor Cuomo took place. Join me now to talk more about this. Kevin Daley, Supreme Court reporter for the Washington Free Beacon. Kevin, thanks so much for joining us today.
Tony, it's good to be with you. Merry Christmas to you and your listeners.
Well, thank you. I appreciate that. Same to you. Kevin, you've kind of put this together where the dominoes are falling. It began with the Supreme Court right at Thanksgiving, blocking New York Governor Andrew Cuomo's worship restrictions. Now this is going all across the nation.
Yeah, that's exactly right. And I like that idea of the domino effect because I think it's a nice visual for what is happening in all of these cases. As you say, on Thanksgiving, the Supreme Court, on a 5-4 vote, said that Governor Andrew Cuomo's worship restrictions in force in New York State were unconstitutional. Those limits restricted church attendance to 10 to 15 people per entity. Since then, we have seen a number of emergency appeals reach the Supreme Court from California, from Colorado, and New Jersey. And in all of those cases, we saw lower courts siding with blue state officials and upholding these church attendance limits. And what the Supreme Court has done is erase all of those decisions and tell the lower courts, have another swing at this, take another look. And when you do that this time, watch what we did in the New York case and follow our lead. So they've done this, as I say, on 3 occasions since December 3rd. So they're sending a very clear signal to the lower courts about the direction of these religious liberty challenges.
Yeah, Kevin, I found it interesting in the dissenting opinions yesterday with the liberal minority where they were saying, well, I mean, the governors there have already changed, I think it was pointing to Colorado, already changed his rules. But just like I think it was Justice Gorsuch in the New York case said, wait a minute, just because he changed the rules as the petitioner was getting to the courts doesn't mean they cannot come back and do it another time. So what's important about these cases, it appears to me, and you correct me if I'm wrong, but as these cases are going forward, it's going to keep these governors from reverting back to these overreaching guidelines that they're placing on churches.
Yeah, I think that's right, Tony. I think we are not going to see a kind of reversion back to the original pandemic restriction policies. You mentioned Justice Gorsuch and his concurrence in the New York case. He has a very nice line in response to this argument. And the argument is, blue state officials will amend their coronavirus policies at the last minute when these cases get to the Supreme Court, trying to head off a defeat. And Chief Justice Roberts and the liberal minority have gone along with that. They've said, look, this case is moot, and if these restrictions arise again in the future, the churches can just come back to us, and we'll see what we can do for them then. But Justice Gorsuch has this very punchy line in concurrence. He says, none of us are rabbis wondering whether future services will be disrupted as the high holy days were, or priests preparing for Christmas. That's a quote from his opinion. In essence, he's saying it's easy for you dissenters to say that the plaintiffs should just live with the uncertainty, but things look very different from the perspective of a church or a synagogue.
Yeah, very well said. And to imply somehow that it's easy just to knock at the door of the Supreme Court. I mean, it takes months, if not years, to get before the Supreme Court. And I think many of these power-hungry governors are playing this not only to save a defeat, but also to save their power for another day.
Yeah, and I think these restrictions, of course, will only be enforced for so long as the pandemic is an issue. But I think one thing to keep an eye on going forward is as the pandemic begins to recede, as the vaccine becomes more available to the public, for how long will blue state officials try to keep these worship restrictions in place? We have already seen lots of public health experts say even after you get the vaccine, it's going to be important that you wear masks for the foreseeable future possibly all the way through 2021. Whether or not they will attempt to do the same with these worship restrictions is an open question, although, again, I think the plain signal at this point from the Supreme Court is that's not going to be tolerated.
Yeah, and Kevin, one of my concerns all along has been, there'll be another pandemic, there'll be another crisis, and where we leave off with this one will be where we begin with the next one. And so I think it's extremely important, and I've spoken to a number of the attorneys in these public interest law firms that are defending some of these churches, not to back up once the rules are changed or if a governor, gives them what they want, but to press this forward so that we are establishing in law the supremacy of the First Amendment and the just how foundational religious freedom is in our society, and how the way we keep it is by exercising it.
And I think to that point that the precedents that you have or the decisions that we have seen from the Supreme Court of late are encouraging. Really, we've heard two things from the conservative majority in recent cases. One, religious rights are special. As you say, Tony, the First Amendment protects them. So strict scrutiny, the toughest degree of judicial review is going to apply anytime there is a worship restriction in play or a church attendance limit in play. Second, and this is a closely related point, a lot of blue states have tried to justify these restrictions by saying it's true, we've set limits on church attendance or religious education, but we've applied those same limits against similar secular activities like concert going or watching movie in the theaters. So, any activity in which large numbers of people are arriving and departing at the same time, spending time together in an enclosed space, those are all going to be subject to our attendance limits. And on that point, what we've heard from the justices, and this, I think will be good law for a long time going forward, is it doesn't matter if the state is subjecting churches and all like entities to these attendance caps. It's no answer to say that the concert venues are closed too. What matters is that some secular entities like the liquor store or the fly fishing shop are still open. And once the state starts creating a list of favored businesses, it's on them to show why churches are excluded, something they will very rarely be able to do.
Yeah, no, great point. Of course, I know I don't want to mix apples and oranges, but in reality, the effect is the same. One of my pet peeves in all of this is the way airlines are treated. I know it's governed by the federal government, but I'm on planes 2 or 3 times a week, and every seat packed, people sitting elbow to elbow for hours. That's okay, but sitting, a few people in a pew for 60 minutes, 90 minutes, not okay. It's hard for me to wrap my head around why there is a double standard, and I think that's what the court is getting at.
That's true, and those double standards are going to be increasingly difficult to maintain going forward. One other thing I would say is in May we saw an opinion from the court in which worship restrictions for Nevada were upheld, and Chief Justice Roberts wrote a very short separate opinion saying, in essence, that state officials should be given broad latitude to respond to the pandemic, and that courts really should not interfere with them. That decision was really very important. It's been cited over 100 times in the lower courts over the summer and the fall, upholding various COVID restrictions, some not even having to do with religion. And in these cases, first the New York case and the 3 cases from California, Colorado, and New Jersey we've been talking about, mark a sharp departure from that kind of hands-off approach that the Chief Justice and his liberal colleagues were espousing in the early phases of the pandemic.
So is that decision already in the dustbin of history?
I think it's safe to say that that's right.
Well, that's good. Kevin Daley, thanks so much for joining us. Great information and a very insightful piece that you wrote at the Washington Free Beacon. Thanks for joining us today.